Ooh. What did you do there, Gemma? So today we're going back to basics in terms of contracting. So what we're looking at is, does a contract exist? And in that context, because the two are often linked, letters of intent, both have always been problematic areas in construction and continue to be. So at the moment, we're busy working on, I think at this moment, as in today, I've got at least 2 letters of intent to review. So we're still doing them, even though they're risky. And what I would say is, quite sadly, these issues where it arises about, is there a contract? What does the contract say? What are the clauses? What's been agreed? What hasn't been agreed? They're some of my favourite types of issues to deal with. I know it's sad. So what we're going to cover today, well, first of all, we're going to, as I say, go back to basics and look at the components of a contract. Hopefully, much of that will be a reminder to you. We're going to look at letters of intent and how they fit into, what is a contract and does a contract exist, and also the risks surrounding letters of intent. And we're going to finish up with this 2018 case of Arcadis and AMEC, which big news for the lawyers, for the construction lawyers, because that was all about letters of intent. And of course, all of this isn't just an academic exercise. It is always, at the end of the day, wanting to find out what the terms of the contract are, usually because some ancillary issue has occurred where the parties are in disagreement, and usually one party will be relying upon one scenario, the other will be relying on another scenario, which is why, this is, it isn't an academic exercise, it is real life and it is important. So, definition of a contract. So, contract is, very simply, it's a bargain or an agreement. It's between 2 or more parties, and it gives each rights and duties at law. As an add-on, it should be in writing, but it doesn't have to be. So, I still get people, coming to me to say, we've got a dispute, there's no contract. Well, the chances are, somebody, I'm not sure if Gemma, can you hear me? Right. Okay. Okay. I'll keep going.
Yeah.
So, still get people saying to me, I've got a dispute, got an issue, there is no contract. I understand what that means. It means there's no, nicely sealed, signed, sealed, and delivered contract. But, please do remember that, if I meet you in the pub and I offer to buy your car for a certain price, and I'll pay you tomorrow and you'll deliver the car, that's a contract, even though we've not put it in writing. So bear that in mind, because what we will see in an example that I'm going to give, one of the parties tried to terminate a contract, and actually a different form of contract was actually in existence, which caused them problems when they tried to terminate it. Slides. So in terms of, we've seen that written contracts are fine, oral contracts are fine, not so good actually, because at the end of the day, if I've agreed to buy your car for X thousand pounds, and tomorrow when you deliver it and I actually give you half of that money and claim actually that was what we agreed, it's a bit difficult for both of us because we've got nothing in writing and it's basically your word against mine. Obviously mine would be believed by the court, and I'm just joking there. But you know, you can see immediately that we've got issues. Also, you know, barring, you know, stupidity and, you know, people being dishonest, you know, there are issues that 6 months down the line, you know, actually, what did you agree in that conversation? You know, it's genuinely difficult to remember. So various forms of contract. Well, the best form from my perspective is one that's in writing, and it's fully executed by all the parties. It's all bound together, or, you know, each page has been initialed, so we know exactly what the contract consists of, and it's been executed as a deed. Or the next one down, all in writing and signed by the parties. It's absolutely clear what is part of the contract and what isn't. You know, that's perfectly fine. In writing but not signed. Now, my example that I'm going to deal with covers that scenario. That's one situation where you do need to be careful. Don't think that just because it hasn't been signed that it's not binding on the parties. It depends upon the factual scenario. And in my case, it transpired that whilst the contract hadn't been signed, it was binding on the parties. So just be careful with that one. And also that one is relevant in the context of a letter of intent where you are in parallel negotiating the main contract. What you may find is that you end up with a dispute over is the letter of intent still applicable, or even though the contract hasn't been signed, the main contract is that binding on the parties because it has been agreed and it supersedes the letter of intent. So be careful with that one. Well, verbal contract but confirmed in writing. Hopefully you're not doing this for your main projects, but this quite often happens in circumstances where you're agreeing a final account, for example. Again, it's an agreement, it's a contract. So, you know, if you have a meeting, it's agreed that, you know, you will be paid X pounds, you know, to finalise your account for the work. It's going to be paid within a week, blah, blah. Put that down in writing and email it to the other party just to confirm what has been agreed in the meeting. So you're not setting out new terms, you're just confirming what was discussed and agreed. And then, of course, we've got the old, you know, verbal contract, you know, agreed in the pub, and very difficult, assuming there are no witnesses, to say who's right or wrong if there's a dispute. Oh, I've got it's saying, can you still hear me? Can you hear me? Yeah.
Bear with me 1 second. Apologies, people.
Okay.
We seem to.
So I'll keep going. So we're now on to slide headed components of a contract. So three fairly simple components here, simple on the face of it. Number one, we need an agreement. Number two, we need consideration, so that's payment, and that's what makes it a contract that's legally binding, as opposed to something where you know, you're just agreeing to do something for someone as a favour. And you also need intention to create legal relations. So the consideration point, you know, is probably the easiest for us, because at the end of the day, if you're a contractor, you know, you are doing work to get paid. So hopefully you get your consideration into the contract. And generally, if a fee isn't agreed, then the courts will agree that it's a reasonable fee to be paid. Intention to create legal relations, in one respect, is fairly simple. Again, you're all operating businesses, so that's on the, so the assumption there is that you are intending to create legal relations. You're not just doing voluntary work. Where this comes into play as being relevant is where you see the term subject to contract. And I've already said you can have a situation where you've effectively reached an agreement, but the contract itself hasn't been signed, but everybody's happy with it. And in that case, that can be then a binding contract. The exception to that is if the contract has been agreed between the parties, where it has always said that sending the contract is subject to contract, which basically means we're negotiating this subject to contract. So even when we've agreed all of the terms, because it's subject to contract, it is not binding until we have signed it, which is what subject to contract means. So keep an eye out for that, and that will feature in the example that we're going to look at. So the final one of that three, so just as a reminder, it's agreement, consideration, intention to create legal relations. The final one is agreement, which is probably the trickiest of them all because it's subdivided into offer and acceptance. Now, we're going to go through all of those components, but the next slide
apologies, I am fighting with the presentation slides at the moment.
Don't worry. No pressure, Gemma. I've got the next slide is a simple one, but the next one is really tricky, so I need.
I'm on it.
Don't worry. So before we go on to looking at the agreement and offer and acceptance element, consideration and intention to create legal relations in a little bit more detail, I also want you to think about what are the key terms in your contract, just as a checklist. So if you think about the 4 Ps, yeah, I know, hilarious, but there's price and what so price is what you're going to be paid, obviously. Performance, what's the scope of work? What are you doing? Because obviously that's related to what you're going to be paid. The period, the time scales you're going to be doing that work in, and then the parties, getting the parties correct in the contract. So from your perspective, looking at entering into a contract with someone who's going to be paying you, making sure that you've got the right company, the company that has the money, rather than, a similarly named related company which has nothing. And where you're subcontracting, again, making sure that you're subcontracting with the party that you intend to contract with. So I'm going to move on to the agreement element of our 3 components. If you remember, it's agreement, consideration and intention to create legal relations. So the agreement is offer and acceptance. And this is probably the most convoluted part, but it's not actually particularly convoluted. It's very, very logical. You just need to be really careful and really analytical about how you look at these elements. And when I say, this is one of my favourite areas, this is it, sadly. So offer and acceptance. So typically, well, anyone with, excellent, thank you. So anyone with legal capacity can make an offer. Now we're going to come back to invitations to tender and whether they're offers. But in the old scheme of, in the pub, you want to buy my car, for £20,000. Oh, yes, please, that would be great. When will you deliver it? The offer is, do you want to buy my car for £20,000? So that's the offer. As it says, it can be made in writing or orally. What are the problems with oral offers? Exactly the same as with oral agreements generally. In 2 hours' time, how do we prove what the terms were? I think there's also an issue around, you know, if you're discussing things, there's a tendency to be a bit more slapdash and not consider all the issues, as opposed to if you're putting it in writing. And of course, there's always problems where you have an oral agreement and contract goes swimmingly for the first 6 months, but then there are issues, and then you're relying on what people recollect was the agreement and what was discussed. So the acceptance must be unconditional, so accepted in full. So, you know, not, you know, oh, well, you know, I think so, but, you know, let me have a think about it or anything like that. Similarly, and I think we'll probably have a slide on this, if the response is, well, that sounds great, but, you know, how about 15,000? Well, that's a counter offer. And what it does, two things. It's then putting the person making the counter offer as the party making an offer. And what it also does is it automatically rejects the offer that was made to sell for 20,000. Now, that's worth remembering in terms of settlement negotiations. So an offer to settle is made by a client, you know, we'll settle your final account for £500,000. Contractor responds and says, that's not sufficient, I'll accept 600,000. That 600,000 is an offer, but it is also a rejection of that 500,000. So if client says, no, not paying 600,000, contractor goes back and says, well, go on then, I'll take the 500,000. Client might just be happy with that. Now, they might have had second thoughts in the meantime, and would therefore be entitled to say, well, actually, no, you've rejected that offer, so it's off the table, and I'm not willing to make that offer again. And, you know, sometimes you do see that happen in negotiations, not often, but just beware of it. So consideration, I mean, effectively, consideration is payment in our world. An intention to create legal relations. It's generally assumed in business transactions. As I've said, beware of these. Oh, we've got inverted commas missing. Beware of where it says subject to contract. So just to be clear with that, what you will often see is if you've got your lawyers negotiating a contract on your behalf, all the correspondence between the lawyers will say in the email heading subject to contract, so that, you know, no one can say, right, that's the last clause we've agreed, we've got a contract, let's get going. It's not a binding contract until everyone's formally signed it in whatever form it's required to be signed. Also, letter of intent. That's relevant to an intention to create legal relations, because some letters of it, the whole purpose of a letter of intent is that both parties are signing up to it because the main contract, so usually, you know, it might be the main NEC form of contract or JCT contract that the parties are intending to enter into, hasn't been fully negotiated and finalised. It may not have, you know, the negotiations may not have even been started. So the purpose of the letter of intent is basically we haven't agreed on the final contract, but we all agree that we need to get on with the work. So let's do it under the letter of intent. So at that point, what you are expressly agreeing is you have not agreed your main contract. So you haven't agreed your NEC or your JCT. So the only contract that you have, if you have one at all, is the contract that is formed by the letter of intent, which needs to fulfill all of our criteria, offer an agreement, so our offer and acceptance. It has consideration in it, so payment, and intention to create legal relations. So what you might see, and particularly not so much now, but in the olden days, so maybe 5 years ago, no, Well, yeah, probably. You don't see them very much. But what you used to see quite a lot would be literally a 1-2 line letter of intent, which would say something like, from the client, we intend to enter into an NEC contract for these works with you once we've fully negotiated and agreed it. But in the meantime, can you crack on and set up its site? Can you do some site investigation? And can you do certain works? So literally two sentences. And the problem with that is that it doesn't necessarily comply with our criteria for a contract, because in particular, the letter itself says we haven't agreed the contract yet, the NEC, etc. It doesn't confirm that the letter of intent is itself a discrete contract. So just be careful of that. We don't see it so much now. What we now see is a letter of intent which is a number of pages and complies with all of our requirements. It sets out those 4 Ps. It sets out the requirements for a contract. So we have agreement, offer and acceptance. We have the consideration, intention to create legal relations. One final point on this, a very, very sad case, I think. Be careful of doing, it said, be careful of doing negligent work for friends. But, be careful of doing any work for friends, sadly. Because this case, I think it was a landscape architect, had given some, I think it sounded a little bit like, some advice over a glass of wine on a Friday night to some friends about some landscape architect work that was being done to the friend's property. The friend then engaged an independent consultant and contractor to do the work. Something went wrong on it, and they actually sued the friend who'd given them preliminary advice at the start, hadn't been paid for it, and the court said that was negligence. It's not a contract claim. It's out with the contract law, but it's part of the law of tort, which is basically a common law law of wrongs. And the court said that the friend had been negligent in their advice. So, the simple moral of the story there is don't give any advice to your friends, and definitely don't give any advice for free to people who aren't your friends. So just to kind of put all that offer and acceptance in a little bit of context for construction, because I'm conscious that typically your contracts won't be I want you to do £2 million of civil engineering work, and that's all discussed and agreed at the pub. So how does all this offer and acceptance work in the context of construction? Well, typically an invitation to tender will be issued by a client, typically to a number of people or a number of businesses. It might just be to yours though. So where does that fit in the offer and acceptance? Well, the law says that it's not an offer, it's basically an invitation to offer. So examples of that are ITTs, and also, for example, if you see something in a shop window, or if you pick up something in a shop and go to pay for it, you are, oddly enough, offering to the shop owner to buy it. And this impacts if, for example, it's wrongly priced, and the shopkeeper notices that and says, oh, well, actually, no, this isn't the right price. You cannot then say, well, you made me an offer, and I'm accepting it. That doesn't work. You are actually making the offer to the shopkeeper to buy whatever it is for a certain price. And if it's wrongly priced and they question it, they are perfectly entitled to say, no, I'm not accepting your offer. And I'm not going to sell you it for that. So, and I know in reality it doesn't work like that, but that's how the law deals with it. And so the same with ITTs. It's an invitation to treat. So it's asking you to make an offer as contractor. So what you need to be careful of is that if you make an offer, so if you submit a tender, then if it's accepted, you're bound by it. So you're basically stuck with it. You can't then say, oh, well, I've missed some provisions out, or I wanted this, or I wanted that, or I didn't actually really want to do the work even. If the client accepts your offer, then you've got a binding contract, and if you refuse to do the work, you would potentially have to pay compensation for breach of contract to your client. Now, I appreciate that in reality it doesn't always happen like that. Typically, the tender may have caveats and there may be issues to discuss on it. There is an exception to this invitation to tender point. If you sent an invitation to tender where the client says, this is the invitation to tender, the lowest price will be guaranteed the work, or something to that effect, then that's an offer, because it is committing the person who's sending the tender, so the client, to accepting whatever the lowest tender is. But I mean, that happens fairly rarely anyway. I think we've probably dealt with the first 2 points here in offer and acceptance. Just remember, it is possible to withdraw or revoke, same thing, an offer at any time before the other party's accepted it. Once they've accepted it, you can't withdraw it. And this is where I say, you know, this is all logical stuff, and where I kind of get really interested in it is that usually, and we'll see this from the case law, this is all kind of hidden within usually lots of emails or other correspondence between parties negotiating the contract. So you need to kind of, if you're negotiating it, excuse me, you need to keep a clear handle on, you know, where you are in terms of offer and acceptance, counter offers, and withdrawing offers. Now, again, it's unlikely that parties are going to want to withdraw offers. It does happen, circumstances change. Where you may want to think about this is, for example, if you make an offer of settlement and things, you know, it may not be accepted immediately, things might change, you might want to withdraw it. So again, you just need to keep an eye on things like this, so that if the position changes, you know that you can withdraw the offer. And that ties in with the next bullet point, which is that offers can lapse. So generally speaking, it's the old, you know, it's the old thing that we always have at law, that an offer will remain open for a reasonable period of time unless you put a specific deadline on it. So, you know, to avoid this problem of having to say, you know, what's a reasonable period of time, I think for loads and loads of good reasons, you know, it's always a good idea to time limit any offer. And that means that, it gives everyone some focus to get things moving. Hopefully it means, and I'm talking more where you're discussing settlement here, you don't end up with a situation where you make an offer, they don't accept or reject it, discussions continue, things go on, you forget about the offer, your position starts to look a bit better, theirs starts to look a bit worse, they panic, and then they quickly jump in and accept your offer, and you're left thinking, oh, actually, I wished I'd withdrawn that, or even better, put a time bar on to avoid it kind of just continuing indefinitely, because even though we've got a position where, you know, an offer will lapse after a reasonable period of time, you're left in a really difficult position if an offer you made 3 months ago is suddenly accepted. Scenario exists that I've just discussed. Your position's got better, theirs has got worse. So, you know, actually you'd forgotten about that offer. And if you had remembered, you would have probably withdrawn it. You avoid all of that problem. And you avoid the problem where the other party comes back 3 months later and says, I'm accepting your offer, and then what do? Do you then have a dispute about, oh, actually, my offer had lapsed because a reasonable time had expired, or do you just accept it and agree that it's resolved even though it's not really on the terms that you would have wanted at that point? So just as a matter of practice, I think when you're making an offer, always time limit it and say, this offer is open for acceptance until Friday at 4 p.m. this week, 21st of whatever, 2020, when it automatically expires. We've done counter offers. As I say, it's a new offer and it also rejects any previous offers. But it's worth bearing in mind that a request for more information isn't a counter offer, so it's neither an acceptance nor a rejection. But that's the scenario where, as I was saying before, where we're talking about revoking offers, time limiting offers, and has an offer lapsed, where you can get into that risky area where you make an offer, someone asks for more information, you provide it, they ask for a bit more, things drag on, and then you forget almost that you're talking about an offer, and then all of a sudden they've accepted it, and you're thinking, oh, wish I'd withdrawn that offer because it's not appropriate now. Subject to contract, I think we've already covered that. Okay, so we've got a little scenario here. This is a real life scenario where we went to adjudication on this. So what had happened? Now, let's just have a little spoiler alert. Oh, I haven't put it in actually. Right, so the spoiler alert here is, why was this all relevant? Why get the lawyers to argue over, is there a contract or isn't there? Why did it matter? Well, it wasn't just an academic exercise. What happened here was that the contractor was doing work on a letter of intent and negotiating the main contract in the background. And when the works under the letter of intent came to an end, the client said, right, that's it, we don't want you to do any more work. Now that came as a bit of a surprise to the contractor because it thought that it was doing all of the work. It thought that the agreement on the main contract had been reached. And the problem was that the contractor had obviously planned various resources to be engaged doing the whole of the contract works, and it was cut short, so it ended up having plant machinery, personnel, etc., with nothing to do. So obviously, that had a financial implication, and so they came to me to ask what they could do about it. So what had happened? Well, first step was the client here, so I'm talking about the employer. Client had issued an ITT, an invitation to tender, and point two, contractor reviewed it, submitted its tender. Price was for £500,000 for the whole of the works, that is. And there were a couple of caveats. So, your typical tender, it wasn't something really that the employer would be able to accept because there were a couple of queries, and there were also some caveats. The usual sensible thing. Contractor's not responsible for ground conditions. Blah blah blah. And much of that wasn't contentious. So at number 3. Oh, actually, it was a contractor-subcontractor scenario. So it's the contractor who's submitted the ITT. So the contractor confirms to the subcontractor that, yes, we're going ahead with you. Subcontract's going to be issued, but of course they still had, these few outstanding queries that have been raised in the tender. So at point 4, The outstanding terms and conditions and pricing was agreed between the parties in a telephone conversation. So they dealt with all of these little points that had been raised in the tender that had been submitted. They cleared them all off, and it was all done in a telephone conversation between the two parties. Now, fortunately, at number 5, the subcontractor finished the telephone conversation and promptly sent an email to the other party in the call to confirm everything that had been agreed. So really good. Nothing more heard from that individual. And at number 6, the contractor submitted, actually, I think a draft contract had been submitted with the ITT. So at number 6, they submitted a revised draft subcontract. So the subcontractor, perfect scenario, did what everyone should do, checks the revised subcontract to make sure that everything's in apple pie order. All those clauses that have been agreed in the telephone conversation have been incorporated, and horror of horrors, they realised that none of those provisions that had been included in the telephone conversation had been included. So again, textbook stuff, subcontractor does exactly what it should do. It writes to the contractor to say, thanks for the contract, but it doesn't include blah, 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 all the terms. In the meantime, different people have a pre-start meeting. So different people for both contractor and subcontractor. Don't really know what's been going on, because of course it's mainly been going on in the form of telephone calls and emails between, you know, 2 high-level individuals. So in the pre-start meeting, contractor says, right, we want you to get started. Contract hasn't been agreed yet. So the subcontractor does what, you know, it's been told in seminars to do, to say, oh, we can't start on site without some form of a contract. Oh, well, will a letter of intent do? Yeah, send one over and we'll see if it looks okay. So that's what happens. Subcontractor actually starts on site, and then this very basic letter of intent is issued, authorising small amount of work, £25,000 worth. The letter of intent work is done, and then, as I've already said, the contractor does the dastardly thing and says to the subcontractor, thanks very much for doing that £25,000 worth of work. We don't intend to proceed further. Thanks very much. Submit your invoice and we'll see you later, kind of thing. So subcontractor comes to see me, we look at the paperwork, and I say to them, well, actually, what happens here, and I have moved the slides back, is that at point 5, the contract has actually been agreed. So at that point, the main contract has been agreed between the parties. At 6, in error, the client didn't incorporate the correct terms, but we say that at 5, the contract had been agreed. Now, there are all sorts of it, you know, it sounds dead simple, but obviously it was very, very complicated. But there were different arguments. So, for example, the contractor said, you know, that at 5, no, we didn't. I mean, they said, no, we didn't discuss those issues. Now, obviously, we said, oh, well, that's odd, because, you know, the subcontractor sent an email at number 6 confirming that. So, you know, at what point did you come back and say, no, we didn't agree that? Well, unfortunately, the contractor hadn't. They also tried to say that it was all subject to contract. Some of it was at the start, but then they stopped putting that. So that didn't even work. And they, quite rightly, and I would have done the same, argued, well, we worked on a letter of intent and everyone accepted that. And we said, well, yes, but, you know, that was a mechanism. You know, it was agreed by, you know, people who were going to work on site. It was different people, didn't know about the contract. So, you know, it was just a mechanism. It didn't and it couldn't alter the fact that the contract had been agreed. Unfortunately, not unfortunately, fortunately, the adjudicator agreed with us and said, yes, the main contract had been entered into, £500,000, and therefore the subcontractor was entitled to its losses. So, a good ending, but shows, some of the problems with letters of intent and surrounding this offer and acceptance. So just some conclusions on that. What's the contract? What does it say? What are the key terms? Is it in writing? Also, critically, and we're not really been talking about this, make sure that you've got all of the contract, because so often, we have the legal version, the form of the contract, but the specifications nowhere to be seen. Letters of intent, reasons why we have letters of intent. Well, they're all practical reasons, really. They're all there. And as we saw in that last example, if you're a contractor going on site, at short notice to do limited works, having a letter of intent is far better than having nothing at all in writing. So, these are some of the reasons that we have letters of intent. Start on work early. Who does that benefit? Client, usually. Sometimes the contractor. Sometimes the contractor's keener to get on site than the client. Carry out investigatory works, site setup. Quite often what you've got to be careful of, though, is that then morphs into something more, and the contractor ends up doing substantial chunks of work under a letter of intent. Provides the contractor with the comfort that it's going to get paid, because it's got something in writing to say it will get paid, which is what the subcontractor wanted in that example that we've just been through. Guaranteed work, which is often why contractors keen to get on. But once on site, my view is that quite often the contractor loses negotiating power. It's quite difficult to then walk away from the project, but equally, it's quite difficult to negotiate, and particularly if you've signed up to a letter of intent. Usually it will be on the client's terms. Usually contractor won't have looked into it in too much detail and will have signed it quite often in good faith that it can negotiate the contract terms later on. And I think quite often what happens is that when the contractor then says in the negotiations, oh, well, I would like this clause in, I don't want to be responsible for ground conditions, for example, or I want to cap on my liability. That comes as a genuine surprise to the client, because the client's thinking, well, you've been working on this letter of intent and it doesn't include those clauses. And they're quite, those clauses, they're quite a big deal. If the contractor really wanted them, surely they would have included them in the letter of intent. So it does cause issues. And, I think quite often they are genuine issues between the parties. Letter of intent terms can be onerous. And yeah, as I've already said, sometimes, because it's very much issued by client, contractor doesn't really have much input into it, just gets on with the work. There aren't the clauses there that the contractor needs to protect it. And that becomes particularly relevant if the letter is extended, as often happens, and the extent of the work goes beyond what the parties initially anticipated. So we've got here, so this second bullet point is the quote. So it's not, 10 years ago, that's not, in terms of case law, that's not too long ago. So this is one of the comments from one of the judges talking about the perils of beginning work without agreeing the precise basis upon which the work is to be done. The moral of the story is to agree first and start work later. I don't know who the judge was. I don't think the judges nowadays would say something like that, because, they've all, fairly recently been construction barristers before they became judges, and, they understand the real world. And as that third bullet point says, you know, that's all very well, you know, in the legal world, but, you know, in the real world, you know, it's just not always practical. So there are two types of letter of intent. I've already dealt with this. So the binding and non-binding. The non-binding is fairly easy to tell because it's that typically it will be literally 2 lines. There'll be no commitment to pay, and it will basically say, we're going to enter into a JCT or an NEC or some form of contract with you in the future. But, you know, it'd be really great if you could get on and, you know, start your site setup, do some site investigations, and, you know, let us know when you've got that finished. There's no commitment to pay. And because it's specifically saying we're going to enter into the contract with you in the future, you've not got any intention to create legal relations at this point. So the work that is being done under that letter of intent is being done for free because there is no intention to create legal relations, because by saying we're going to enter into a contract in the future once we've agreed and negotiated and agreed it, you are saying, you know, it therefore follows that there's no contract, you know, at this point, as opposed to a binding letter of intent, which will be more than 2 lines. It will be, you know, at least a couple of pages, and there critically there will be a commitment to make payment for the work within that letter of intent. So, you know, it might say, you know, this letter of intent's being issued, you know, pending, you know, us agreeing, you know, the main contract, you know, that is going to be under NEC. But in the meantime, we'd like you to do this work, site setup, ground investigations, etc., etc. For this work, you know, it might be, you know, letter of intent work, letter of intent scope, limited scope, whatever. You know, for this limited scope, we'll pay you £50,000. You know, we want you to do it in the next 2 weeks, blah, blah, blah. So you've got, you know, your key terms in order to carry out that work, and a key commitment to pay. Right, so we've done that. Yeah, we've done that. I don't want to go through this scenario, but what I do want to do is look at this fascinating case of Arcadis and AMEC. Now, I think the first thing it's the first bullet point here. So the dispute went from the High Court to the Court of Appeal. So I said, this is bad news for a start. Well, why? Well, you know, it basically means lots of legal costs for both parties, because it's gone from the High Court to the Court of Appeal. The other thing to bear in mind here, and again, this is a spoiler alert, the High Court decided it one way and the Court of Appeal decided it another. Why I mention that is that, you know, when your lawyers talk about the risks of litigation or, you know, the risks of adjudication, to an extent, that's what we're talking about. And it's quite difficult to kind of to get to grips with it because, you know, logically, you know, I can see that, you know, particularly the engineers amongst you will think, well, you know, my job as, you know, an advisor and a designer is to produce something that's, you know, structurally safe, you know, structurally blah, 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 safe, you know, does the job, etc. So the lawyers, you know, as advisors just say, oh, well, there are risks of litigation that are very difficult to deal with. But what it relates to in part is that, you know, judges make awards, adjudicators make awards. They are all just people. They all have different backgrounds. They have, you know, different ideas about how things should be done. You know, they're not machines who, you know, are always entirely consistent. And some of them place different emphasis on different things. So just a little lesson in the risks of litigation. So what happened here? Well, AMEC was the subcontractor on a pretty big project, and they were engaging Arcadis as designing consultant. So what it was effectively there were 2 projects. the Welcome Building and the Castle Point car park. And the intention of the parties was to enter into a full contract that, to me, was probably a little bit like a framework contract, which would apply to both projects. But obviously have project-specific information for each. But what they seemed to call it was a protocol agreement. But I think it was intended to work in the same way. Agree one set of terms and conditions, and it would apply to both projects. So they initially started on the Welcome Building, and then they started on the Castle Point car park, and it's the Castle Point car park that's the subject of the dispute. And what happened, again, a little bit of a spoiler alert, was that once the Castle Point car park had been completed, they discovered that there were defects in it. And the rub here was that the estimated cost of remedying those defects was £40 million. That's right, 40 million. So, you know, this is quite a chunky claim. So the allegation was that Arcadis's work, the design was defective, and that was the cause of the defects, and therefore that Arcadis should be responsible for paying this £40 million to remedy the defects. So of course Arcadis weren't too happy with that, understandably. So they looked at the contract documents and said, well, we can see that there's a cap on our liability for just over £600,000. So even if, which we deny, even if we're negligent and we're responsible for this, the maximum liability that we have is £600,000, which, you know, as you would imagine, would be a huge relief for Arcadis if that were the case. AMEC were having none of that, so it initially went to court on that basis, and AMEC said, you know, actually, no, you're liable in full. So that's what this was all about. So, as I said at the start, this is never an academic exercise about, oh, you know, let's find out what this contract's all about. You know, there is always a reason for it. So on the example we dealt with earlier, it was to work out what termination losses, if any, were due to the subcontractor. On this, it's about a cap on liability. So what happened? Well, the parties were negotiating, and we'll call it this protocol agreement, which is just like a framework, and was going to be the contract that dealt with both projects. So they were negotiating it, got to the stage where they wanted to start on the car park, hadn't completed the protocol agreement, so of course they issue a letter of intent. The letter of intent referred to the protocol agreement and said, the protocol agreement is, in the course of negotiation, we intend to use it for, this project as well as the Welcome project once it's all been finalised. And the protocol agreement contained a limitation of liability. Now, it said that it was capped at a sum in Schedule 1, and at the time the letter of intent was issued, that fill it in bit, what's the cap amount, was blank. But several months later, whilst they were still working under the letter of intent, whilst Arcadis were working under the letter of intent, AMEC issued another version of the protocol agreement, and at this point they'd inserted a cap of 10% of the contract price. So where we get to 600,000 is that was 10% of the price for Arcadis doing the work. So that's why we're talking about the cap of 600,000. The reality is that the cap is this 10% figure, if you want to be entirely accurate. Now, the cap was actually rejected by Arcadis in the negotiations. They were wanting something better. They didn't actually finalise the protocol agreement. The works were finished. So it goes back to my point about risks of doing work under a letter of intent. In this instance, they did all of the work under a letter of intent. Not uncommon, I would say. the protocol agreement was never finalised. The defects were discovered, and then we're in the High Court for the first round of the dispute to find out what the contract is, and critically, does the cap apply? Now, what the parties both accepted was that if the protocol agreement had been agreed between the parties, then the cap would apply, because by that point, I think the 10% had been accepted. But the High Court said no, it hadn't been agreed. There were still key issues that hadn't been agreed between the parties. So irrespective of the cap being agreed or not, there were other issues within that protocol agreement that weren't agreed between the parties. So they didn't have a final protocol agreement. It hadn't been signed, but as we've already seen, it doesn't have to have been signed. But unlike my previous example, where the parties had agreed all those issues that needed to be agreed, there were in this instance some outstanding issues that were still being negotiated between the parties. And to work this out, the court actually had to go through probably, I would say, pretty much all of the correspondence between the parties relating to the protocol agreement, the negotiations, and the letter of intent to work out, and this is where your offer and acceptance, it does become, a real analysis to work out, right, on this date, how many issues were still not agreed between the parties, right? 5, okay. 2 weeks later, we can see, an email where one of the parties agrees item 1, a day later, item 2 is agreed, and you've literally got to go through and analyse what's agreed and what isn't. But anyway, the High Court said no, protocol agreement hadn't been agreed, and it was fairly clear to the High Court that they were working under a letter of intent. The letter of intent was a binding contract, so it was a nice, lengthy letter of intent setting out obligations between the parties. It was a sort of mini contract between the two parties, that I suppose morphed into something more. But the court said the letter of intent didn't incorporate any cap on liability. So sadly for Arcadis, there was no cap. Now the court didn't decide whether Arcadis had been negligent or not, but obviously that's really bad news for Arcadis, because it was really hoping that the court would say, irrespective of whether you're negligent or not, you can only ever be responsible for 10% of your contract price, so for that £600,000. So Arcadis then took it to the Court of Appeal. The Court of Appeal pretty much agreed with the High Court, except for one point, the critical point, which was it said that that cap on liability had been incorporated, not into the protocol agreement, interestingly, but into the letter of intent itself. And what it did, and it shows the level of scrutiny that you've got to exercise when you're looking at these things. What it said was that the letter of intent, when it was issued, said that the terms of the protocol agreement applied insofar as they were agreed between the parties. And what the court said was that for the purpose of the letter of intent, the cap on liability had been agreed. So it kind of, and this is why I say, this is a good example of the risks of litigation, because both courts, both sets of judges, really bright people, but, they've come to a different result by very, very slightly different means. So, what's the moral of the story here? Well, I think it is to be careful about letters of intent, but this isn't just, sorry, I'm just clicking through because we've dealt with all of this. It's not just about letters of intent. It's about contracts generally, you know, it's fine if your contract is signed, because, you know, then it is clear what the terms are, even if you then face problems about, well, you know, which terms within the contract apply. You know which the terms are. You might have a disagreement about what they mean, or which ones take priority, but at least you know which ones they are. Whereas, you know, what we're seeing here is a debate, you know, taking a step back as to, you know, which terms go in the contract and which don't. You know, this kind of dispute is common with letters of intent. It's also common where you haven't got a signed contract. So, you know, just be really careful about this, and remember, you know, these issues of forming a contract. So, you know, an agreement, offer and acceptance, consideration, intention to create legal relations apply to your letter of intent as much as to your main contract. So that's everything for today. Happy to deal with any questions if there are any. Pleasure. Yep, can.
Wants to in the next minute.
Yeah, I mean, what I always say, I think my contact details are on the slide. So, you know, if you think of anything, drop me a line. I'm happy to pick up any questions, and I promise you won't get a bill, just just in case you're wondering.
Well, what I'll do is I'll send out to everyone who's attended, I'll send out a PDF of the slides. We've had a few people ask whether they could get a PDF of the slides. So I can get that sent across to people and make sure that they've got your contact details as well.
Sure, that's fine.
I have got a message from Allah who said, Gemma, you can share the PowerPoint in the chat box and we can download it. Do you know what? Who knows what might happen if I do that? And it could all go horribly wrong. And I'd hate to delete you all on this lovely Thursday afternoon. So I'll just email it across to you because, you know, I'm feeling comfortable with that. So I'll get those across. But unless we've got any... Oh, hold on. We have a question here. Just bear with me. Ba, ba, ba. There we go, Sarah. Can you see that?
So I think, Caroline, if I'm not answering the right question, just type away. But I think you're asking me about a binding letter of intent and a non-binding letter of intent. So if you're not, quickly type away, and I'll change what I'm dealing with. So the one that you've got to be worried about as a contractor is the one that very, very simply, it'll be a couple of lines, so it's quite easy to spot, but it will say something like, you know, really looking forward to working with you on this project. We want to negotiate the JCT contract with you over the next few weeks, but in the meantime, can you just crack on and, you know, set up site and do a bit of site investigation and blah blah blah. Thanks very much. Speak to you later. Fred Blogs. So that the problem with that is there's no commitment to pay. And the real problem, it's two things in conjunction with each other. There's no commitment to pay for that discrete bit of work that they're asking you to do. So the site setup, ground investigations. And at the same time, they're saying, looking forward to working with you. We're going to negotiate a contract. And it's those two things together, because in saying, we're going to negotiate a contract with you for this work, what they're also saying is, we're not entering into a contract with you now because we're negotiating it in the future. So it's those two things. Whereas your contractual, just wanted to know what the ITT indicates as your contract. Just wanted to know what the ITT indicates. But without withdrawing the offer. Oh, sorry. Oh, Yeah, right. Contractual position on, yeah, sorry, I'm thinking of letter of intent. Right. Yeah, so the contractual position on the ITT, contractually bound. Yeah, so if an ITT is issued, then that is not an offer. So if you, as a contractor, I'm not sure which end you're coming from this. I'm assuming you're a contractor. If you, as a contractor, put in a price, that's, you can't say, oh, well, I've accepted your offer. You are actually making the offer by submitting your tender. And that tender is then open for offer by the client. So if you put in a tender that basically says, yes, we accept your contract, or if it, if the invitation to tender says, this is the contract, all what we want is a price for this work. We want you to start on this date, complete on this date, and we just want a price, and you submit a price, then effectively you're making an offer that it is that price on the basis of all the criteria set out in the invitation to tender. So if the client accepts that, you've had offer because you've made the offer as contractor, and you've had acceptance because your client has accepted. And at that point, you're stuck with it. You cannot pull out of it. So that's just applying the principles of offer and acceptance to that ITT scenario, which applies to anything else. So in the way that if a letter of intent is issued and you sign it, you've accepted it, or if you say yes, that's fine, or if you say yes, I'm starting work, again, you've accepted it and you can't withdraw from it. I hope that's answered the question.
Caroline's just added one small bit.
If you said, for example, because what often happens is, from my perspective, the tender's put in, but the tender says, well, we need to discuss clause 2 because we're not happy about that of the contract, or, we would, this is subject. It sort of depends on the caveats, because if you say, our offer is on the basis that clause 2 is deleted, clause 4 is deleted, and clause 6 is deleted, and we're not responsible for ground conditions, then, and that's accepted, then that is accepted. If it's more, this is subject to discussing and agreeing certain clauses, which I know lots of tenders say because they don't want to actually say, we don't like this clause, that clause, or the other. If it's that, then it's just not something that is capable of being accepted. So it needs to be a clear offer.
Okay, I just had one more comment on. You see that, Sarah?
Yeah, thanks, Wellington.
Just for anyone who've got a couple that
are
on the phones, I'll just read it out. So, interesting one about the Arcadis case. How come the court mentioned that there is no cap for the liability, while the intent of the LOI is to give time to negotiate this point, which agreed and settled to be 10%? Would this mean that the decision of the court should be in all cases, logically, should be less or equal to the final agreed one in the negotiated contract in case they have to pay?
Yeah, and again, this is the court. I mean, it's partly construction of what the parties were saying between each other in the letter of or what the letter of intent said, and partly just reading what the actual terms of the letter of intent said. And I appreciate your point that this is the whole point of negotiating, but the issue here was that both courts said the letter of intent is a standalone contract. So that's the first point. And once you get your head around that, the court will say, well, I'm reading this letter of intent and construing it. The problem was that the first court said the cap hadn't been incorporated. The second court said it had been incorporated into the letter of intent. And why it said it had been incorporated was because the letter of intent said that the terms and conditions between the parties that were current with regard to that framework contract, the main contract, the protocol agreement, as they called it, applied to the letter of intent. And you often find that in letters of intent, because sometimes you will have part negotiated your contract, your JCT or your NEC or whatever. You'll enter into a letter of intent, and what the letter of intent will say is you're doing the work on the terms of this letter, but also the NEC contract applies with the amendments that we have negotiated so far. So, effectively, that was how the court interpreted it.